interviews, and we have Mr. Nierman first. And welcome, and we're ready to hear your opening statement.
Thank you, Justice Wiggins.
And I see you have some company here. You want to introduce them to us?
Yes, thank you. I am here with my best friend, high school sweetheart, and wife of 30 years, Lisa. To her right is our son, Hunter. He's a marketing analyst for a national restaurant chain based in Coralville. And next to him is our daughter, Laura. She is a junior high English teacher in North Liberty. And I'm also privileged to have here Michael Bootsma, a member of the Iowa Bar, Dean's Teaching Fellow at Iowa State, my first law clerk and very good friend. I'd like to open my statement discussing what I believe is one of the most significant issues facing the judiciary, and then close it with a short story that reveals what kind of justice I intend to be. In Federalist 78, one of the founders warned about the danger of courts imposing their own preferences rather than applying the law. He stated that if the courts were, quote, disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. In other words, if courts, no matter how well intended, focus on the outcome of a case, they will take over the will of the people as enacted through their elected officials. One of the many ways that our nation is changing is that people are losing faith in their governmental institutions. And in recent decades, almost every consequential statute or executive order has been challenged through litigation. Whether Iowans will have confidence in their government depends in large part on whether they can rely on courts to exercise sound judgment. As Justice Sandra Day O'Connor put it, the proper role of the judiciary is one of interpreting and applying the law, not making it. This is not an abstract philosophical or political debate on the role of the courts. Rather, the issue goes to the very existence of our republic. If voters feel like they are powerless, they won't vote. And if they don't vote, we don't have a democracy. So as I consider taking on this great responsibility, I am mindful of families trusting the legal system to keep them safe, individuals depending on courts to arbitrate their rights, and businesses relying on the enforcement of laws that govern their investment of capital, while recognizing the absolute necessity of applying a faithful reading of the Constitution, statutes, and precedent, and to do so in a way that builds respect for the rule of law. I'd like to close with a true story. One of the things that I've enjoyed in my life more than almost anything else is participating in my kids' extracurricular activities, from helping build props for the school play to leading scouting trips. It's been just an amazing experience for me to be involved in their lives. And I remember one instance in particular. I was head coach of my son's 6th grade baseball team. It was early in the season, and the umpire didn't show up for the game. So I went to one of the dads on the team, a man that was rightly well respected in the community and had a very tender love for his son. And the other coach was fine, and of course, eventually his son came up to bat. There were 2 strikes, I think it was a full count, and a pitch came. There's no swing. It was close, but I personally thought it was a strike. And so I looked intently at my friend's face. And what I saw was this grimace of pain. And then almost a half second later, I heard this broken-hearted strike 3. And, you know, there's a lot of things that he could have done at that moment. I mean, he could have lied and said it was a ball. He could have changed the strike zone for his son and everybody else that came after. But he did the one thing that was required of him, and that is that he applied the strike zone to the pitch. And I think that so almost perfectly, to me, demonstrates the kind of judge that I would be if I was so fortunate to be selected, and I think it's a model for the judiciary as a whole. And I would be happy to answer your questions. Thank you.
Thank you very much. We'll start on this side. Mrs. Pearson? Oh, you need to take a mic. I don't want to get another text.
How's that? Is that good?
Perfect.
All right, very good. One of the questions that I ask each of the applicants that I met with via phone or in person as to how they would, of course, add value to being one of the justices, not only their personal abilities, but thoughts on improvement, expansion, things that might make the public more aware, more educated about the judicial system, and you talked about some innovation, being a person that likes to use innovation. And would you share some of your thoughts with the rest of us, please?
Sure. I think court administration is very important, and having spent 7 years in corporate America and 16 running a small business, I've had lots of opportunities to think about innovation and business matters. You know, one of the things in a small business is that you have to do a lot with very little resources while wearing a lot of hats. And one of the things that we're dealing with in the court system is very limited resources. And during those 16 years, I faced this situation over and over again. We don't have enough resources to do what we want, but we've got to take care of our customers. And I think to look at things from the view of our customers is really important. So as we look at our customers in the court system, the people of Iowa and everybody who walks through the courthouse door, we need to be thinking about how they view the system. You know, when judges and lawyers get together and talk about court administration issues, often what we discuss is district court and appeals, and those are very important. And yet today, the vast majority of the people that go through the courthouse doors will not be district court or appellate litigants. They'll be coming there because of small claims, jury service, or simple misdemeanors, also known as traffic tickets. And how are we going to connect with them there? You know, it's not uncommon for us to schedule 8 small claims cases at one time, or have a dozen initial appearances in traffic tickets. And in a sense, we have a system that is designed to make people wait. And I think this is really critical that we look at this from the customer's perspective for a number of reasons. One is, you know, if we have 12 people coming at 9 o'clock to plead guilty or not guilty for a traffic offense, and the judge has a whole hour to hear those cases, let's schedule a third at 9, a third at 9:15, and a third at 9:30. And this isn't just to, you know, kind of a PR thing. You know, if we go around and look at the hallways of our courtrooms and see people waiting, and we're able to calculate that and say, you know, everybody theirs was, you know, worth $50 an hour to the Iowa economy. You know, if we multiplied that times 5 days a week, 52 weeks a year, and 99 counties, that would be a lot of value to the Iowa economy. But more importantly, it sends a signal about justice and how accessible justice is. You know, think about the young lady who, maybe a single mom, who got a ticket. Maybe she deserved it, maybe she didn't. But if she has to wait a half an hour to plead not guilty and get a court date, and she's late for work, how's that going to affect her perception of our legal system? And what happens if she's the victim of a crime? Maybe it's a horrible crime, a year or two later. Is that experience with the court system going to impact her negatively in terms of whether she should reach out for help? Maybe a crime that was just extremely personal. And so I want to be a part of a system that, even though we have limited resources, is thinking innovatively, creatively, from a customer perspective. Yes, we've got limitations, but we've got to solve these problems and make this extremely friendly to our customers.
Thank you.
Ms. Bowden? Mr. Berger? Mr. Diaz?
Mr. Nierman, we've now established that you would call your son out at home. So what I want to do is kind of dovetail on that. How do you put up this concept of, let's just call it like we see it, with the reality that, and the tradition in Iowa, that we've been at the forefront of a lot of civil rights movement at one form or another, including the Barnum decision in 2009 that brought about some changes in this court. How do you square those two together? When is it appropriate to sort of, call it outside of those lines and say, maybe that's not really a strike, maybe it's going to be a ball? How do you do that?
Yeah, it's a really important question. I've had the tremendous fortune to represent some amazing people. I remember a few years ago, I represented a young lady. She was working 40 hours a week at a fast food restaurant to put herself through college. And the store manager had just repeatedly sexually harassed the female workers there. Many of them, like her, were poor. And with my client, he had also assaulted her. I remember an African-American man, very distinguished man, came to my office just brokenhearted. He was at a convenience store with a white friend. His white friend was allowed to use the restroom. He was not. So part of this is it's really important that we know the people that we're serving. The problems that we have here, and even though Iowa has been historically on the leading edge of addressing some of these problems, they're still here. And ultimately, the people of Iowa are going to have to take responsibility and do something about these things. And I'm not saying the courts don't have a role here, because they do. They have a really important one. Sometimes there has to be a vacuum. There has to be this situation where there's a problem, people take ownership for the problem and address it. And sometimes the problem has to get kind of big before people really say, we are Iowans, we can't have this happen here. And I think there's an element of that we need to have. One of my favorite pro bono projects has been a school on the southeast side of Iowa City. And our church rented a portion of an abandoned box store 10, 15 years ago and started a youth group. And it was perhaps a marginal success or a marginal failure. But it struggled partly because we were reaching kids when they were 13, 15, and they had already made a bunch of life choices and more significantly, decisions about themselves that made it difficult for them to achieve. And by the way, this box store was abandoned because it was in a very poor neighborhood with lots of crime. And so we said, well, we've got to start earlier. And so we started a kindergarten and first grade and added a grade each year. This next month we'll have sixth grade. Our church has since bought the box store and the strip mall next to it, and it's been amazing. If you looked at a picture of the student body, you would reasonably guess that 80 to 90% of the students were of color. Many come in below grade level, and they are outpacing their public school counterparts. We've kept class sizes really small. We've fundraised 90% of the tuition. It's not just our church, it's community-wide now. And the parents have to agree to volunteer, to host parent-teacher conferences in the home. And if you go into the school, and any of you are welcome to come and take a look, you constantly hear, hey, scholars, listen. Hey, scholars, come here. Because we are training them that it's their mind. They have to perceive themselves as smart as they really are. And they have to memorize this creed. It's like 3 or 5 minutes, and they have to recite every day, sometimes multiple times a day. I am smart. I can become a doctor or an artist or a poet. And so, part of this, a big part of the piece of the puzzle here, I think, is to go to the roots of the issue.
Dr. Taylor? Mr. Bevel? No. Mrs. Sinclair?
I just want to congratulate you on your work with that school. That's amazing, and if we could have that in every poor neighborhood in the state and in the country, we would not have nearly the problems that we have. Just continue that.
Well, thank you. My role has been relatively small, but it's been just a real pleasure to have some small part.
Ms. Diekma?
We have to watch our feedback, I hear. Thank you for your application. I'd like you to address the issue of mentoring. You just were talking a little bit about that, but how can our Supreme Court assist with attorneys coming up in the mentoring issue? Have you thought about that issue? Could you expand on that, please?
Yeah, that's an issue I've thought a lot about. The bar talks a lot about mentoring, and rightly so. I think the thing that we don't like to admit is that a lot of what passes as mentoring is really senior partners training associates how to make money for the firm. And there's nothing inherently bad about that. But for us to have a thriving bar, it has to be much broader than that. And so, as I've had opportunities to interact with people like Mr. Bootsma, we don't just talk about the law or career decisions. We talk about ethics. We talk about, okay, so you've got this career and you've got a young family and you've got to make decisions about your time. So I think, so more specifically, the answer to your question, sometimes we just have to do it. Sometimes we just have to lead by example. Sometimes we have to say, I'm going to take my bucket out of the ocean and I'm going to fill it as full as I can. And I am going to look outside of the people that have had huge privilege and look to the younger people. And, the future lawyers of our state aren't just in law school, they're in high school and grade school. So mentoring has to go outside the parameters of the legal community as well.
Mr. Sukup? None. Mr. Goodman?
None, Your Honor. Thank
Mr. Bloom?
you. None, thank you.
Mrs. Conover? Mrs. Roberts? I have a question or two. Tell me about, it seems when I got on the court, I found out we did a lot of things, a lot of areas, and your area's sort of been very limited. Not a lot of criminal law and things like that. So, how do you think you could get back in the swing of things? And does that cause you any problems?
Yeah. So, as I put in my application, I started with a very general practice. I was the proverbial retired couple would come in with a box full of receipts, and I would help them with the tax return. I got to do business transactions and real estate transfers, and started doing criminal work. And I had the incredible privilege of representing some, not many, but a couple of criminal defendants that truly were not guilty. Not that got them off on a technicality, but they just didn't do it. And that was some of the most rewarding work that I've done. I had a criminal trial 2 or 3 years ago. I've since kind of, just got more and more focused on insurance. The law is something that we don't put into kind of neat boxes. So, if a orthopedist has to do surgery on someone who has the surgeon has to know a lot more than just orthopedics. And same way, the law doesn't just, come in neat boxes. So if I help a young child with a large insurance claim, I'm going to be involved in the probate court. So more specifically, in answering your question, Justice Wiggins, I have a practice that continues to touch on a lot of different areas. So I think I'm going to come ready to do the work in diverse fields of law. I think the other thing that comes to mind in answering your question, sometimes as lawyers, we just have to figure out what we don't know. I represented a man who had a business. He sold civil defense sirens. And so I had to learn a lot about civil defense sirens. In one of the cases that I described where I helped this lady get the life-saving surgery she needed, I had to go to the Health Sciences Library at the University of Iowa and look at medical journals and find out everything there is to know about this condition that would affect her case. And I would bring that same type of energy and determination to the court.
One other question. We see as a court, and it's not just in Iowa, we go to these various seminars and meetings, and we're seeing people abandoning the court to settle their disputes, going to alternative dispute resolution for one reason or another. What's your opinion on those things, and how would you bring people back into the court system?
Yeah, I'm sorry, I'm
People
not sure I
back into
understand
the
your
court
question.
system.
Yeah. I had the privilege of taking Richard Calkins's class, Dean Calkins's class on mediation about a year ago. And, he still, at his age, is doing amazing work. I think there is a place for mediation that's really important. The empirical research indicates that people are much more satisfied with the outcome of their case when they mediate it, when they get it resolved. And it's not for every case. But I think it's healthy when people can work with their adversary, often through a third party, and find a resolution. And the interesting part of the empirical research is that even people that would win at trial and get more money or have to pay less money, depending on who they are, still find these early resolutions more satisfying. And so again, to go back talking about focusing on our customer, if it's better for our customer to resolve their case early, then we need to help them do that. And if they need to have their day in court, then we need to have the resources there for them.
Okay, thank you. I don't have any further questions. Anybody else? Well, we thank you for your appearance this afternoon, and we wish you the best of luck.
Thank you.